The reality is that 99% of cases do end up settling, and not everybody is going to be happy about it. But when it comes down to the day of trial where it's time to make a decision, a lot of people really don't want to take the risk of going to, if it's a misdemeanor, county jail, or of a felony, actually potentially going to prison for a year.
Welcome to Hot Docket, the show where we talk about winning marketing strategies that have built the most successful law firms.
Join us every 2 weeks for the latest trends and tactics to grow your law firm.
Hey, everybody. Welcome to the Hot Docket podcast. Today we have with us Shane McKeen of McKeen Law out of Atlanta. Shane practices criminal defense, and we're really excited to chat with him today about all things criminal defense.
Hey, good to talk to you guys.
In the world of DUI, I know that's probably where the majority of your cases kind of lie. I can imagine stuff like this that's more complex in nature is probably less of a concern. And I'm assuming things like, proper procedure on the part of officers and kind of like making sure that chain of evidence or what have you is kept intact. There's probably more like procedural things that you care about when you're working the cases that you're working. But I'd love to hear, I'm just making I'm making that guess as somebody who's not a lawyer and knows nothing. If you could walk us through kind of like what is important in your cases and kind of what typically hinges a successful or an unsuccessful case, that'd be helpful for us.
Right. So the most successful outcomes you're going to get are where there were procedural issues. DUI is has to be done very by the book. You get the occasional case where you get an unusual situation, circumstantial driving, civilian witnesses who may testify to seeing things, but the 99% of DUIs involve traffic stops or checkpoints, and then officers going through a standardized set of field sobriety evaluations that they use to determine if someone is impaired or not. So you start with the traffic stop. What if it was a checkpoint? Those are pretty cut and dry. They have to follow a written procedure that's established in advance in order to do these DUI checkpoints. They have to be randomized, and a lot of people get caught up in it that way. But probably most are just very minor traffic violations, things that you would not get pulled over for during normal hours. But at 2 a.m., 3 a.m., they're looking for slight weaves, leaving your lane of travel, weaving within your lane of travel. Any of those things can justify a traffic stop. So that's where we initially look to see if a case can be defended, because if a traffic stop is illegal, the whole case is out. But not something that you're going to typically see, but we do look for it because it does get you kind of that instant win if you can beat a traffic stop and find that it's not legal.
So for the easy wins, when let's say the police officer doesn't show up, can you give us a rough estimate for how often for any of your case types you go to trial and the police officer just doesn't show up?
Yeah. I always tell clients not to expect that to happen because that is not a typical outcome. Funnily enough, I did have it happen in the last month or so, totally unexpected, where a police officer did not show up for trial, but that generally does not happen. And showing up for trial means you've already gone through years of waiting. You've already gone to a calendar call. You've gone to an arraignment, maybe a status hearing, maybe a motions hearing, before you ever get to the point where an officer has to show up. Okay, so it's not you go to your first court date and the officer is not there and case gets dismissed. A lot of people think that's how it works. Not how it works. You go through a lot of sitting and waiting through court hearings before you ever get to that point. And the only way you're going to get that instant win, get that dismissal, is if the officer's not there and the state doesn't know why he's not there. Usually they know why he's not there, and the judges will be very lenient with giving them another shot.
Got it. Can you run us through any other misconceptions that people commonly have?
The biggest one definitely is that, and something a conversation I have with people daily, I feel like, is the officer did not read me my rights. That's a very big conversation that I have with people all the time. And it's, I hate to be a downer on all of these, but an officer does not have to read you your rights. And they're referring to Miranda rights, or I assume they're referring to Miranda rights. In a DUI case, or even most criminal cases, I do more than just DUIs, but in most criminal cases, Miranda rights are not going to be an issue. It only comes up when you're being interrogated after you've already been arrested. So the thing about DUIs especially is most of the investigation happens prior to an arrest, formal arrest actually happening. And the only question you're asked after a formal arrest is whether you want to do a blood test, whether you want to do a breath test. But at least in Georgia, our courts have found that you don't have to read Miranda prior to asking that question.
Is there ever a scenario you should cooperate without having your lawyer present?
So with DUI, and this comes up a lot in videos of traffic stops that I see. Well, with DUI, you're not going to get a chance to have a lawyer present. But with other cases, no, you never, if it's not traffic related or you're not going to have the opportunity to have a lawyer present, no, you never want to cooperate, attempt to talk to the police, talk them out of doing what they've probably already decided they're going to do.
Got it. Okay. To pivot a little bit, can you walk us through your tools of the trade? Like, what are the tech tools, or, not tech tools? You could give an answer like Microsoft Excel. What are some of the tools that are like indispensable to your work?
Criminal defense, at least with what I do at the state level, I would say is pretty low tech. You'll have to give me an example. We're just using basic computer skills.
Like, do you guys use CRM like Clio or Filevine or anything like that to manage court dates and understand when, key moments are in the life cycle of one of your matters? Like, are you using anything on that side?
So I'm trying to incorporate some AI tools to make some of those things more streamlined. Right now, I've got someone working on something for me. I'm not sure what site they're using, but it involves more of a CRM than I've had in the past. But as my volume has increased, that's definitely become more necessary. Right now, it's very manual. Google Calendar, Dropbox, alerts of those nature. And it's really, for me, because of the way criminal defense works, you're trying to prepare for things as far in advance as you can. So I really just have a task list based on what's coming up on my calendar, because some of these cases, and with a lot of cases, I may not touch them for a year. Nothing may happen for a year after the initial inception of the case. So I'm just looking at what's coming up, and there's a lot of manual work in law. I wish it were easier to streamline that way, but at least with me, I feel like there has to be a lot of physical hands-on to actually know what's happening with the case.
What's the maximum number of files you think a criminal defense lawyer can hold at one time and be effective?
It's going to depend on your staff. I would say more than a couple hundred is probably going to be pushing it. But it depends how serious those cases are. If you're talking about murders, things that are definitely going to go to trial, those are going to be more labor intensive than DUIs, drug possessions, maybe a domestic violence matter, things that are more cookie cutter. Okay. And once you've done it for a while, you know what you need to do for the cases that are more that fit in those boxes evenly. So it just depends how many complex matters you have. I wouldn't want to have more than 10 of those at any given time.
Shane, to change gears just a little bit, can you give us a background on how you became a criminal defense attorney and kind of your origin story?
So what first got me interested in law was criminal practice. I was in a community college and I took a class that was taught by a former prosecutor who worked at a local prosecutor's office prosecuting misdemeanors. And that's what really got me interested in it. The procedure of getting from college to law school is definitely a slog, because you're just trying to get a degree so that you can take the law school entrance exam, and then you've got another 3 years after that. But I always wanted to be in criminal. So those were the internships that I sought out as I went through. I was able to intern with the U.S. Attorney's Office for a while in Atlanta as well. And then I prosecuted for about 5 years before starting my own practice. The prosecution side of it was mostly DUI, misdemeanors, traffic court was where I spent time prosecuting.
What's the biggest mindset shift between being on the prosecution side and criminal defense side?
So you still really look at cases the same way. I don't really think you can be effective if you have a bias one way or another, but you still look at cases the same way. But the biggest mindset shift is getting to know the person who's charged, because when you're the prosecutor, you don't get to know them. You don't really want to know them, because I think that would make it difficult to do your job. But as the defense attorney, it's much more getting to know the person and humanizing them in front of the court to the prosecutor. That's the biggest mindset shift, I would say, because you go from, well, can I prove my case, to now I'm looking at it, well, can the state prove this case? But also you're dealing with people who have a lot of questions, and there's a lot of tough conversations that have to happen.
Yeah, from the outside, I would think that, like, when you talk about what is hard about each of these, sides of the bar that you're operating on, it is probably a very different, like, if you had to point to one thing that is the hardest thing about being a criminal defense lawyer and the one thing that is the hardest thing about being a prosecutor on the other side, I could imagine that the set that set would be very different. Like, on the prosecution side, what you said around not necessarily wanting to know the defendant, I could imagine that being very difficult if you look across and you see somebody who has a family and, like, maybe is a good person besides for one thing they did, and knowing that the stakes are high, that you might be kind of like destroying their life. And on the other side, on the criminal defense side, I can imagine it might be very hard that kind of like in the same vein, you might find somebody that you really don't like a lot, and you think that they've got a lot of views that are questionable, but you have to put that aside to fight for their rights in their case. So, like, for me, that's kind of like my naive interpretation of what some of the difficulties could be, but I'd love to hear from you. Is that aligned with your experience, or is there something that I just would never even know is like the hardest part about being on both sides of?
So I feel like being a prosecutor is not that difficult in a lot of ways, because you have policies that you have to follow. You try to treat everybody the same, and it can make your decisions a lot easier. And at the end of the day, you're not responsible for what happens to the defendant. But when you're the attorney, you really take all of that on. All of the problems that this is going to cause people, not just directly, but collaterally, you take all of that on. So I feel like the job in that sense is much harder. The actual law side of it, we could argue it either way. But yeah, the effect on families, the explaining to people the stakes, the risks, that is the most difficult conversation to have, because while I encourage any client to fight their case, especially if they believe that something was done wrongly, ultimately they have to be willing to take that risk, because we can't guarantee outcomes in this space. Not that you can really in any type of legal proceeding where you have someone on the other side trying to make your job harder. And that's the hard part of it. And not only do you have the person on the other side making your job harder, you've also got the judge involved in there too, to whatever extent they're going to get involved.
Can you think of a scenario when you and your client had very different views on whether you should take a settlement offer, take a plea deal, or go to trial, and kind of how you work through that?
Sure. And this happens all the time. And the reality is that 99% of cases do end up settling, and not everybody is going to be happy about it. But when it comes down to the day of trial, where it's time to make a decision, a lot of people really don't want to take the risk of going to, if it's a misdemeanor, county jail, or of a felony, actually potentially going to prison for a year.
How do you work through differences that are so deep? That is probably it's not an irreconcilable difference, because you have to work through it. But your client wants to go to trial, you want to take the plea deal. That's a pretty wide gap. How do you bridge it?
Right. Sometimes you don't. Sometimes you do what the client wants, even though you advise them differently. But sometimes you really have to be forceful with explaining what could happen, because the range of penalties for these things are so unknown. You really have to sit a person down and say, look, this is what you're facing. This is what could happen. A lot of times clients will ask for a likelihood. What's the percentage, this or that, what could happen? And the range is so broad that I just have to say, if you go for it, it's maybe all or nothing. You may be sitting down in the county jail for a month, 2 months, up to 12 months on a misdemeanor, technically, although that's uncommon. But yeah, sometimes you don't bridge that gap and you just move forward and you put up your best case. Sometimes it goes in your favor for reasons you might not know, and sometimes it doesn't. And that's the unknowable part of dealing with juries, especially if you're talking about a jury trial, because you don't know what's going to happen. Juries can do whatever they want for whatever reason they want. They're supposed to follow the law, but having talked to jurors many, many times, the things that they do for the reasons they do it are totally unpredictable. So I don't like unpredictability, and I don't think most clients do either.
Can you walk us through what your jury selection process looks like?
It's going to be very dependent on the judge. You want to insert as much arguments, insinuation about what your case is going to show, but some judges are very limited on what you can ask, and it's going to vary depending on what the case is. For a DUI trial, for example, since we've been kind of focused on that, you want to know what people's attitudes are towards alcohol, drinking, driving. Have they been arrested for DUIs before? Have they had bad experiences with police? Have they been negatively affected by alcoholism, getting hit by drunk drivers? Those are the things you really want to try to suss out in those cases. But some judges are pretty strict with what they're going to allow in jury selection. Technically, the purpose of it is to find out who's going to be biased and who's not. And there's no hard rule on what's allowed in jury selection, but I try to focus on elements of my case, depending on what the case is, that I can ask about to see if there's going to be similarities between experiences that they've had and experiences that my client has had. But a lot of it really is feel. Looking at looking at their profession, looking at their age, looking at ethnicity, although there are rules about how that can be implemented, but it applies more towards the prosecution than it does to the defense. But you want to get rid of the people who you think will be the worst for your case. It's not about selecting the jurors that you want. Nobody gets the jurors that they want. You want to identify the people that you don't want, and then everybody's left with the people who didn't fall into either of those categories.
Okay, so when you brought up occupation, we've gotten mixed reviews on this one. How do you feel about selecting someone who has a spouse that is an officer?
Police officer, family and friends of law enforcement. Depends how closely related they are, but from a defense standpoint, that is probably not somebody you want on your jury for a criminal case. Absolutely not. You might strike them just for that reason.
Are there any other big no-nos on the occupation side that you would strike out?
I probably would not keep another attorney on my jury.
Can you walk us through that?
Sure. So the issue with having lawyers on your jury in any type of case, I speak more towards criminal, is that they know or should know what's kind of happening behind the scenes. They'll make assumptions, and there's a high probability they're going to end up being your foreperson because other jurors will look to them because, hey, they're supposed to know what's going on here. And you don't know what experience they've had in the past. You can't get into all of their legal experience during jury selection. You can try, but the way their laws are written are not necessarily defense friendly. And if you follow the letter of law on these, it's akin to maybe having a bench trial. And so the reason you have a jury trial as a criminal defendant, as opposed to letting the judge decide, is because you don't want another lawyer to just follow the letter of the law and make a decision based on that, because a lot of the time it will not go in your favor. So I would consider it a big risk, unless I probably wouldn't even pick another criminal defense attorney to go on my jury for the same reasons.
Any other occupations that you would strike out?
Just on its face, no. But the more sophisticated the job, so you get into engineering, engineers, people who may have a lot more questions. Those are people that sometimes we tend to avoid, because we want jurors who are going to listen to what's presented and not try to think outside the box with what they're going to do. Now that can cut both ways. Obviously, we don't know which way that's going to go, but we want jurors who are going to listen to what we're presenting. And I can't really specify the exact occupation where that's going to be a problem, but I do take a bit more care with people in professions that are just going to be more questioning of things, maybe more scientific, because the case they're going to see might not meet up to the standards that they expect.
Are there any other, outside of occupation, are there any other things that you would look to remove?
Well, you mentioned law enforcement. Aside from that, you want to get rid of people who are going to be real pearl clutchers with what they might hear, because a lot of people have no idea the type of crime that's happening in their community, and they're going to be more likely to be offended by what they hear. And I would, for criminal defense especially, I tend to look for younger jurors than older people, retired people, just because I think they're going to be more likely to give somebody the benefit of the doubt than someone who has maybe more life experience and is going to feel like they know what's happening behind the scenes. So younger from a defense standpoint, we definitely would like a younger juror.
Shane, I think it's a good time for us to kind of wrap everything up here. I'd love to just end with a couple of less professional topics. The first is any books that you think people would enjoy reading, whether it's related to your profession or not.
Books. So you're looking for fiction books, professional books.
But if you have anything that you think can put people in the minds of like a criminal defense attorney first and foremost, or like tools of the trade book, let's start there. If you don't, then yeah, what's a top fiction book?
I would say if you're asking about books, there are some John Grisham books. I can't think of the name right now, but there are some they're real just short page turner type books that are actually pretty do somewhat reflect what actually happens, more so than you see on TV. In the mindset of the lawyer, man, I can't remember the names of some of these books because I've read so many of them. But I do find that his depictions are not are more accurate than probably what you see on TV, the popular legal shows. But professional books, no, that's a terrible answer. Sorry.
It's fine. And then the second one is, how can people find you?
How can you find me? So really just Google my name. I'm trying to bump up the Google reviews, but just search Shane McKeen or McKeen Law in Atlanta, Gwinnett County, Fulton County, Cobb County. I work all in the metro area. My website is McKeenLawAtlanta.com. And I'm available pretty much around the clock. If you send me a message through the website, I get back to people as quickly as I can. So I'm easy to find.
Awesome. Well, thanks for hopping on this episode of Hot Docket, and we'll see you on the next one. Thanks, Shane. We hope you've enjoyed this episode of Hot Docket. We're your hosts, Bobby and Andrew, founders of MeanPug, the marketing agency for ambitious law firms.
Have questions about marketing or anything we covered today? Email us at mark@meanpug.com. Be sure to subscribe to learn more. Until next time.